Hello friends, in the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax versus KALINGA METALICS Limited. This case has been reported in 455 ITR page number 553 and the matter has been decided by Calcutta High Court and the date of the judgment is 24th June 2022. The purpose of discussing this case is that this case is regarding the allowability by the courts when the appeals are filed late, or in simple words about the condonation of the appeals. When the appeals are filed late and an application is made before the courts for the condonation of the appeals. In this case, the appellant was department and there was delay in filing appeal by the department. The plea of the department was that the department has to route its appeal through the Department of Law and Justice. The officer is involved, the counsel of the department is involved, and the approval of the Law and Justice is involved, so that the proper decision should be taken. So in this case, due to delay in approvals from the Department of Law and Justice, there was delay. Although the court allowed the delay, but the court at the same time said that the court is unable to understand why the appeals are filed through the Ministry of Law and Justice, because it only delays the matter. The Ministry of Law and Justice is already burdened with the litigation of the other department also, and the court said that it will be better if there will be a direct coordination between the counsel of the department and the officer who is going to file the appeal. The importance of discussing this case is that in this case, the court discussed the various guidelines of the Honorable Supreme Court which has been given in the celebrated case of collector land acquisition versus Miss Katiji. This case is related to 1987 year and the case has been reported in 167 ITR page number 471. In this case, the Supreme Court has given various guidelines which should be adopted by the courts in allowing the condonation. The first guideline is that the Supreme Court remarked that litigant does not stand benefit generally by filing the appeal late. When the appellant is not benefited by filing the appeal late, then in that case the condonation should be allowed. The court said that when condonation will not be allowed, the effect of not allowing the condonation will be that a meritorious matter will be thrown out at the threshold. The Supreme Court said that maximum what will happen if the condonation will be allowed. The court said that if the condonation will be allowed, then the maximum effect will be that a cause will be denied on merits. The purpose of the court in this case was that the appeal should be heard on merits. The Supreme Court in that case said that there is no doubt in the mannerism of condonation that each day delay should be explained by the appellant, but at the same time a pedantic approach should not be adopted while allowing the condonation, and the condonation should be allowed in a pragmatic manner. The court also said that when the substantial justice and the technicalities are pitted against each other, then the court should give more weightage to the substantial justice. The Supreme Court also said that the judiciary is not respected for legalizing injustice on technical grounds, but the judiciary is respected for giving the decision on merits. The point of the court was that the injustice should not be done by legalizing or by giving the technicalities on a very hard footing that the cases or the condonation should not be allowed, or the condonation should not be allowed just because of the technicalities. The court said that whenever there is a point of sufficient cause, then the sufficient cause should be understood in an elastic manner and it should not be understood in a very narrow manner. Friends, this case is very important as far as when we are filing our appeals and there is some delay on our part, then we can take the help of this case. This case is very helpful in filing the appeals of condonation. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus KALINGA METALICS Limited, and this case has been reported in 455 ITR at page number 553, and the matter has been decided by Calcutta High Court, and the date of the judgment is 24th June 2022. Thank you, friends.